Democracy and the Court with the New Republic's Jeffrey Rosen at the Aspen Institute in Colorado earlier this month.
It's always a unique opportunity to have a conversation with Justice Breyer about democracy in the courts. But this is an especially exciting time for our conversation today. Since he joined the court, Justice Breyer has been the most eloquent defender of the vision of pragmatism and liberal judicial restraint. He calls this active liberty, and he says that by paying attention to the democratic purposes of the Constitution, judges can promote democratic deliberation, and by paying attention to the consequences of their decision, they can better serve society. Now, as you all know, just a few weeks ago, in the Seattle schools case, Justice Breyer delivered one of the most inspiring, incisive, passionate, and convincing dissents that he's ever written. And if you want to applaud him for that, I think it's well deserved. And I don't care whether you're lawyers or not, all of you have no excuse. Go look it up on the internet. SupremeCourtUS.gov. It's only 77 pages. But believe it or not, it is riveting reading. You'll find that you can't put it down because it is so convincing, logical, and strong in its defense of judicial restraint. Justice Breyer, obviously we have to start with this case. I know you talked about it earlier this week, but not all of us were there. You're now among a small group of friends on public radio and YouTube, so you can speak candidly without any fear of us betraying your confidences. What was it about this decision in particular that set you on fire and got you so worked up?
Is this on? Is it on? Yes. All right, good. Thank you for that introduction, by the way. Now I'm going to have to answer all your questions very thoroughly after such a nice introduction. But I think, can I go back for a step?
Please.
Because I think you'd have to see, which is what you were talking about in general, you'd have to see how, at least I'm thinking of this document, the Constitution of the United States, which I've had the privilege of interpreting or helping to interpret over the past 13 years. It has a few words in it, 7 articles, I think 27 amendments. And after a period of time on the court, I think any judge with the steady diet of constitutional cases that we have begins to see the document as a whole. Now, I can describe in general terms, not 3 words, not 1 word, but probably in under a minute, how I think most of us see that document. Sandra O'Connor, Tony Kennedy, and I were at Mrs. Annenberg, who was doing a marvelous thing trying to get civics taught in the high schools. Couldn't be better. And we were looking at a number of surveys that they took of lawyers. What is the Constitution about? What should we teach first? And some said the First Amendment. Some said equal protection. Some said privacy or religion. But we all used a word that was way down on the list. And that word was democracy. Now, anyone who's a judge will look at the document and say the heart of the document is the first 7 articles, and those articles create democratic political institutions. So if you have to say in a word what the Constitution is about, you say it's about democracy. And what that means is it isn't the Constitution that decides how people should live together. It is up to individuals through the democratic process to decide what kinds of cities, states, towns, and nation they want. And if they make bad decisions, that's up to them. And we hope they'll make good ones, but they're not our decisions to make. It isn't the document. Now, having said the word democracy, you have to add a few words. You say, well, it's a certain kind of democracy. It's a democracy that is protective of basic human liberty. That's the amendments. It assures a degree of equality. That's the 14th Amendment. It divides power horizontally, 3 branches of government, executive, legislative, judicial, and vertically, state, federal, so that no single group of people in government can become too powerful. and it insists upon a rule of law. All right, you see, there we have it. Democracy, fundamental rights, division of powers, equal protection, rule of law. And I think all 9 of us would at that level begin to agree. For at least we'd be in agreement for 3 or 4 minutes. Now, I spell that out because once you see that, you can see the basic job of being a judge on our court. I see that basic job as, well, the document leaves virtually, but not all, decisions up to you. And what we're doing is patrolling the boundaries. That is, it creates a big space for democracy to work, but there are boundaries. And who are we? We are the boundary patrol. We work at the frontier. Now, life at the frontier is sometimes a little tough because it's sometimes filled with very difficult cases. Are they inside that boundary or outside the boundary? Now, that's the introduction. Now I can answer your question. Because in the school's case, what we were asked to do, as I see it, is we're asked to decide whether a certain kind of activity in the school districts in Seattle and Louisville, what kind? They were trying to achieve a degree of integration in the schools. And in particular, they were trying to get inner city kids spread around a little bit so that all those schools would be good enough where you didn't have isolation in the community. Now, to do that, what they did was they had, one, they didn't want forced busing. That was very unpopular, and it led to white flight. So what they did was they said, no more busing. We will, in fact, give every high school student, that was Seattle, or all students in a certain complicated way, a choice. They can go to whatever school they want, but if the school that they choose has too many minority children or too few minority children, what's too many or too few? Well, in Seattle, if a school was more than 85% white, you could have up to 85%, but we want to assure a minority population in every school of at least 15%. Now, if your choice or your child's choice put it over that 85%, the child couldn't go to that school. He'd, in Seattle, have to go to a different high school for a year, and then he could transfer and get a choice that he might prefer. Right, now that's what's in front of us. And the question is, note, it's race conscious, that condition that I just mentioned. It's race conscious. And so the question is, does that race consciousness, that race reference, does it or does it not go beyond the boundary? Well, what's the boundary here? The boundary here is set by the Equal Protection Clause, and the Equal Protection Clause says no state shall deprive any person of equal protection of the law. All right, now you have the general approach. Now you have the question. Now you still haven't got your answer, which is why was I so exercised? The short answer is, of course, I thought if there ever is a case, I overstate that only by a millimeter, if there ever is a case that the Constitution wanted to be left to local school boards, states, local governments, maybe even national governments, but not judges, that's the example. So why not? Why would the court find this so difficult? It found it so difficult, and probably reasonably so difficult. It's not as easy as you might think. And the reason it's not as easy as you might think is the following. Remember those words I just told you, equal protection of the law. Well, there are two words. And as soon as I think of that, I think, of course, there's a difference. And why do I think this is the case? And now this is your answer. One, I think that colorblind view is very wrong. Two, I think it's never been in the law. I think it's never been accepted before by a majority of this court. Three, if my goodness, if there was ever a decision that should be made locally, it is this one. And why do I think that? Because I look at a few facts and figures, and one of them says that one black child out of every 6 is now in a school where the population of the school is 99 to 100% black. because I can read as well as you, and we look around and say there are problems of race and poverty in the inner cities of America. And so to disable the democratic process from dealing as best it sees fit with those problems, of course I got slightly exercised. And the way that I take out my, I guess, the way I show this is I write 77-page opinions, and people are then put to the trouble, a few of them, of having to read it.
Excellent. Well, bravo. I hope you continue to get exercise because it makes for very good reading. But I want to ask you more about precedents. You said that in this case, it was your view that the majority was overruling precedents without saying so explicitly. And it seemed that in several cases this year, that same pattern recurred. The majority insisted that it was respecting previous precedents, and you felt that they were just being less than candid. Is it better for the court to overrule precedents openly, and does the current majority disrespect precedents in this way?
I'll answer the first part of the question. The first part of the question is, in my opinion, it is better to be open. And of course, you know, when I'll give you a couple of numbers. There were 10 cases listed as important cases in the newspaper, if you take that as a base. And I was in the majority twice. That was better than nothing. And in the other cases, in 3 of the cases, the majority said it was overruling prior precedent. And in 4 other cases, the minority or other judges on the court said you are overruling prior precedent. So remember, there's disagreement about this. I thought that there was quite a lot of precedent overruled. But the people on the other side, who were very good judges, they thought that they weren't overruling the case. And here you only have a chance to hear one side of it, and it really, my judicial instinct knows that that's unfair. But still, I have my view. So, I think it's better to be open. It's not the case, never overrule a precedent. That isn't true. It's not right. Think of Brown versus Board of Education. Brown versus Board of Education is a case in which Plessy versus Ferguson, which had been the law for 80 years and created a caste system in America, was overruled. Do I think that was bad? No, I think it was great. I think you do have to be careful about overruling precedent, because people plan their lives on the basis of law. And if law is too unstable, they won't know how to plan their personal lives, their business lives, they won't know how to live. And that is a very undesirable thing. So, if you want a basic rule, the basic rule is you can overrule precedent if you are on a court, like mine, but please be very careful about it. And I think, and explain what you're doing. And focus on the issue why, and say why. Now, of course, I had what I guess a slight, well, and I'll say what I said, and I won't characterize it. In the schools case, I do admit to having asked the question, because I discussed a lot of cases, and I did say, well, what happened to Grutter? That was the affirmative action case in the Michigan schools. What happened to Swan? What happened to McDaniels? What happened to Crawford? What happened to the Seattle School District No. 1? What happened to the Boston School Committee? And I was listing a bunch of cases. And in my view, I said, well, these cases have been vibrant and alive, and now they've been erased from the law. And so I thought that they were not paying adequate attention to the precedent there, the majority, but the other side thought they were. So if you're going to read mine, you better read theirs.
Now, it wasn't only precedent that the court majority said it cared about. In a series of interviews last year, the new Chief Justice Roberts, said that he cared a lot about unanimous narrow decisions that would allow people from both sides to converge on a common outcome. He said this to lots of people, including in an interview with me, of all people, in The Atlantic, which he gave last July. Now, some people thought I was too charmed by Chief Justice Roberts in this interview. He's very charming. And in fact, my wife said that I have a man crush on Chief Justice Roberts based on this interview. So naturally, I was very distressed to look at the statistics of this term and see that far from having a lot of narrow unanimous opinions, there were more 5-4 decisions than at any time in recent history. Why did Chief Justice Roberts fail in his much vaunted effort to achieve narrow unanimous opinions, and might he succeed in the future?
I would say that's a question best asked him. I'd say I've learned from interviews, beware of charming interviewers. I can say, well, I mean, I know some statistics that you're right about there being more 5-4. I was interested because the last full term that Sandra O'Connor was there was 2004 term, 2004-2005. And comparing that to this term, the number of, oh, sorry, yes, good point. The 2004 term, if we compare it to this term, that was Sandra O'Connor's last full term, and this is really our first full year, you know, with the things have sort of got with our new members. The number of unanimous opinions, and I tend to know this, I exaggerate a little sometimes when I talk to audiences, and I talk to school kids, which I love doing. I say, you know, and I talk to audiences about the court, and I'll say, well, about 30 to 40% of our cases are unanimous, and you don't know that because the reporters find those boring. And, but I have to say this year the number was about 32% or so in 2004. This year I think it fell about 10 points to about 22. And I say then, and you know, take the cases that aren't unanimous, really the 5-4s are about 20 to 25%, typical number. All right, this year they went up to 33%. And then if you look, and I then add, and it's not always the same 5 and the same 4, which I'm glad to see that outcome. You know, I don't decide a case on the ground, is it going to be the same 5 or the same 4 or anything like that. It's the job of other people to characterize the overall results. I work on a case on the basis of what do I think is the right answer here. And that's often difficult because, of course, there are two or 3 or 4 different answers. But still, if I look back to the 5-4s, and if, which I hate to do, you were to say, well, I know what you mean by the usual suspects, and that's sometimes for good or sometimes for bad. You're going to say me and John Stevens and Ruth Ginsburg and David Souter. So I look to see how often were we on the same side of a 5-4 case in 2004. And the answer was just over half, around 55%. So it wasn't the same 5 and the same 4. No. This year, 80%. Now, you can say, well, remember that this year may be somewhat atypical, though there are always important decisions and always